Good morning. My name is Starla Leverett, and I'm the General Counsel for the Alabama Real Estate Commission. And I want to welcome you to the first Briefly Legal of 2024. I want this to be as interactive as possible. So if you have a question throughout, please just raise your hand icon and we will call on you and then unmute yourself and then we'll mute you back afterwards. So today we're going to be talking about a topic that everyone loves, and that's money. I'm going to focus on some different issues, some complaints, some questions that the Commission receives regarding money. The first topic I'm going to delve into involves earnest money. There has been a disturbing number of increased complaints from both consumers and licensees regarding earnest money. And this issue involves the failure of the earnest money to be deposited as the contract states. And I think the reason we're seeing this and the uptick in complaints is simply because more and more brokerages are no longer holding the earnest money. Instead, it's being directed to be held by either the closing attorney or the title company. And so because of that, I think we're losing what I call the chain of evidence. Because before, when brokerages always held it, the buyer would turn it over to the salesperson would turn it over to the broker. So you kind of had it in your hand and knew where it was going. Now that it's going to a third party, you may have 10 or 12 transactions that are going on, and you don't realize that your buyer actually did not deposit the earnest money. This is so important because this is completely tied to consumer protection. And there's no faster path to revocation than a consumer in missing money. I do want to point out that currently it is a potential violation if a buyer agrees to pay the earnest money in a purchase agreement and then he fails to do so, then this could be considered a breach of the contract. So under current law, as a listing agent or a licensee assisting a seller, it is your obligation under 342784A2 to inform the seller that you are aware the funds have not been paid, because that section sets forth that a licensee must exercise reasonable skill and care in providing brokerage services to all parties honestly and in good faith. And the seller needs to know, if you know as a listing agent, that the buyer has failed to fulfill one of their obligations under the purchase agreement. If you heard me speak at all in the last couple of months about some pending legislation, you've heard me say that this actually has become such a problem that we are placing it in the violation section. It's being placed there, though, not just to protect consumers, but I also firmly believe that this is ultimately going to protect our licensee community. Because like I said, you have a third party involved, you're super busy, and you just don't even realize the money was not deposited, the deal falls apart, and now everyone's yelling, screaming, where's the earnest money? So in our current legislation that's pending, what we are doing is we're basically saying that you, as the licensee who works with the buyer, you're going to have an affirmative duty to follow up and make sure that money was actually deposited. So you contact the closing attorney, the money's there, that's all you have to do. However, if the money is not there, then you do have another affirmative duty to tell the licensee working with the seller, my buyer didn't bring the funds. Then that licensee must tell the seller the funds are not there, so the seller can decide how they want to proceed with the contract. So again, I think it is an extra step, but it's a step that in the end is going to end up protecting you from all of a sudden realizing there's no earnest money when the deal falls apart. Are there any questions about that topic? All right, seeing none, I'm going to move on. So these are the most common questions we get at the commission from licensees regarding money. Can I get paid my commission at the closing table if my broker agrees to it? Does my prior broker have to pay any commissions owed to me when I leave to my new broker? And can I use a new website that puts salespeople kind of in touch with each other, that if you need someone to cover a showing, that they actually pay for that? Can my client reimburse me directly for any services that I paid for? Like I said, these are the most common questions we get, and they all are covered in license law under section 3427-3614. This statute prohibits a salesperson from accepting valuable consideration for conducting a licensed activity from any person except their qualifying broker. So let's first look at what we call table funding. The commission is very aware that some people practice this, and it basically is when a qualifying broker or company directs the attorney to pay the salesperson directly their commission at the closing table. Please hear me that this is definitely a violation of license law, because that salesperson can only receive their commission from the qualifying broker. And I will point out that in April, we're actually going to have our commission meeting down in Baldwin County. So if you're in that area, please come see us. But we will be presenting a case to the commissioners in April regarding table funding. Are there any questions about table funding? All right, none on that one. So let's move on. This one is kind of a hotly debated topic, but I'm sharing it with you because I want you to know what our perspective is here at the commission. So you have a salesperson that's working with a brokerage, and they decide to leave that brokerage and go to another one. But maybe they have some transactions that are going to close quickly after they leave, and they are owed commission from those transactions because they did a lot of work on them before they left. That money can actually be paid directly to the licensee. We interpret Section 3427-3614 to mean that a salesperson must be paid their commission by the qualifying broker that they were licensed under when that license activity was conducted. That's why we find it appropriate that the previous broker can pay the salesperson directly and not run it through their new brokerage, any commissions that they earned while at the previous brokerage. Any questions about that one? Okay, there's also a practice where a salesperson can ask another salesperson, and I think this happens probably quite frequently, to help them with a showing because of a scheduling conflict. Maybe they need to go out of town, something's come up with their child, and so they usually will do something like get them a small fee for covering that. And in fact, there's been a company on a website that actually links people together, and then they're going to pay them a small fee for doing the showing for another salesperson. Well, showing a property is such a major step in selling and renting process that our administrative code in 790X1.04 specifically prohibits clerical office or employees of a real estate company from showing listed properties. So since showing property is a licensed activity, any compensation for this, even a gift certificate for covering a showing, should only be provided through the qualifying broker. So please be mindful of how these payments are being made when you have someone cover for you. Are there any questions on that topic? All right, none. So another thing I want to talk about is when a salesperson may contribute to the enhancement of the property in order for sale quicker. And so they may provide money for maybe painting, remodeling, cleaning, or lawn service. And the intention is that that owner is going to reimburse them for that. This is not considered compensation. It's considered reimbursement. So it's not, because it's not for performing a licensed act. So license law does not require that reimbursement to flow through the qualifying broker. However, I do think it's wise that brokerages implement policies where they regulate when and where and how a salesperson may front money to a client and how that money may be reimbursed. So the final topic I want to talk about today, because I would be remiss if I didn't, because 2024 is a renewal year, is I want to just start the messaging early to please, please, please triple check when you pay online through Alabama Interactive if you're paying by an ACH check. What happens is when you're putting in your account number, they're not verifying that it's a true account number. So it's going to look like you paid and everything was successful, but then about 4 or 5 days later, we get a notice from the state that they can't find that account. And as you know, it's a violation to remit payment for a fee or a fine, and it comes back unable to process. So because of that, we'd have to file a formal complaint against you. So please just slow down, take your time, look at those digits, enter them, triple check them, to make sure. Also, please remember that when you see your receipt or on your bank account, it's going to say State of Alabama in most cases. It's not going to say the Alabama Real Estate Commission. That's it. So just look at the amount and make sure it matches what your license renewal fee was, and do not stop the payment, because then that also triggers us to have to file a violation against you. But I do want to end this on a high note. As I referenced earlier in our pending legislation, if it passes, or when it passes, I'm going to say, we will take that out of the violation section. So instead, if you accidentally enter a wrong number, and I do truly think the majority of these are accidental, then it'll not be a violation, but instead we will just notify you and give you 30 days to replace the funds. And as long as you do, it's no harm, no foul. So I'm truly hoping that 2024 is the last time I have to talk about this and the last time you have to listen to me talk about it, because it will no longer be a violation. I hope this has been informative, and I hope you join me for the next Briefly Legal. That's going to be on June 6th. I do want to point out that the Alabama Real Estate Commission is always, we want to be here to assist you, and we do that in a number of ways. You can always call us at 334-242-5544. You can email us at arec@aerc.alabama.gov. Our website is arec.alabama.gov. We are also on social media, Facebook, Twitter, Instagram, and YouTube, and I'm sorry, Twitter is now X. And our social media for all of these is at AREC, Alabama Gov. And please remember that if you get an email from us, please answer it, especially in this time of renewal, because it is going to be an important message that we're trying to push out to you guys. And if no one has any other questions, any questions? Okay, I have a question. I thought I made it out of here without a question, but come on. Tony, what is your question? Make sure you unmute your mic, please. I can't, I'm not able to hear you. Did you unmute your mic?
Yes,
Okay.
Yes.
I hear you. You're coming from above.
I was just wondering if there was a reason why the minutes to the commission meetings are no longer being posted on the website.
Oh, they have to be approved. I'm sorry. I was looking behind the camera at my PR person, because they're the ones who do that. We still post them, but they have to be approved at the next meeting before they're posted. So they're going to be a month behind each time, if that makes sense.
Well, they haven't been posted since October.
Okay. Okay, I'm being told that November and January, because we didn't have a meeting in December, are up. But if you, is this Ms. Stanton, Dr. Stanton, by any chance?
Of course it is.
Okay, well, I'd love to hear from you. Let me verify. When I get off, I'll have someone from PR reach out to you so we can verify that they are where they're supposed to be on the website.
Okay, and I did have a question before when you were talking, not really a question, but a comment about the qualifying brokers being, if somebody has a deal with us and then they leave the company. In the past, it's been interpreted that was fine with inactive licensees because they no longer have a broker. But my issue with that is that I don't want any liability for that agent that's left me. Her new qualifying broker is the one that's got that liability. So that was just the only thing I wanted to mention about that.
And Dr. Stanton, I will tell you that it is, some people do it that way. Some people insist upon paying a new qualifying broker, and there's no issue with that whatsoever.
Okay, good.
I've heard it argued both sides from people that, like you, have been in the industry for many, many years, and we have no problem with that. We just want to say that if they did choose to pay that that licensee, we would not consider it a violation. But you are more than welcome to send it to the new broker. Absolutely.
Okay, and I'm sorry, one more question. If you have so much problem with earnest money, why don't y'all require real estate brokerages to have an earnest money account?
That is a very good question. And I will say that from, we wear two hats here. We wear the consumer protection hat, which is what we're mandated to do by the state, but we also, wear the hat of helping licensees and all that. From the consumer protection hat, I 100% think they should have to hold it, and they should have to have a brokerage account, because it goes even further beyond what I've said, because if we take it further, that closing attorney or that title company, they don't have a license with us. So they are not under our jurisdiction. So let's just say we have a closing attorney go rogue. I'm not hearing of this happening a lot. And he doesn't get a mutual release sign, and he just gives it to who he thinks it should go to. There's nothing we can do against him, because he's not under our jurisdiction. So from a consumer protection agency perspective, it definitely, I think, is better for a brokerage to hold it. I just know that from the licensee community, we just hear that they don't want the liability or the responsibility of this, but it is an excellent question. And I think it's one that, if we could get enough feedback from the licensee community that this is something that they think that everyone should have to hold it, or have a brokerage account, at least a trust account, then I think it's something that we would definitely be willing to fight for in the legislature, to say you have to have one.
Okay, I was just curious.
Yeah.
Well, thank you, Starla. I always appreciate you.
Absolutely. If there are no other questions, then I'm going to just sign off and tell y'all I hope you have an awesome day today. See you later. Bye.